Bailiff, you may call court to order.
The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Good morning and welcome to the Iowa Supreme Court's oral arguments. This is our second day of holding these virtually. And I would like to say just a few words about the manner in which we're proceeding. As you're aware, the COVID-19 pandemic has affected all aspects of life, and it has definitely affected how we do business in the court system. The Iowa Supreme Court continues to issue opinions, but we, out of concern for the health of our lawyers as well as the court and staff, we have made the decision to hold these arguments this month virtually. We are proceeding today by way of virtual oral arguments, and we're glad to have this alternative available. Fortunately, the public will continue to have an opportunity to view these oral arguments live streamed. You can get on our website and there is a connection for you to access the YouTube website for arguments. Through this alternative, we continue to provide access to justice while at the same time providing public access to these proceedings. Our court staff has worked very hard to make this technology work smoothly, hopefully. But as many of us know who have been participating in these types of meetings, often there are some glitches. If so, please remain patient and we will get through this together. With those preliminary remarks in mind, I would like to go ahead and announce the cases for this morning's schedule. The first case for oral argument is State versus Timothy Fontenot, State represented by Sheryl Soich and Mr. Fontenot represented by Ashley Stewart. The second case set for oral argument is Benskin Inc. versus West Bank. Benskin is represented by Steve DeVolder. West Bank is represented by Dennis Ogden. The next three cases will be submitted without oral argument. The first one is State of Iowa versus Mario Goodson. The second one is State of Iowa versus Amahu El Amin. And the third case is State of Iowa versus Christopher Hawk. Those last three cases are submitted at this time. We will begin with the State of Iowa versus Fontenot. Let's do a quick sound check, and then we'll begin with the moving parties arguments. I'll start with you, Ms. Soich. Can you hear me? And I'd like to hear you. I can't see you either.
I'm sorry, Your Honor. Yes, I can hear you and see you. And I'm not sure why you can't see me, but I will try.
There you are. Okay, thank you. And now, Ms. Stewart, by the way, when each of you is listening to the other attorney, if you could mute your camera, mute your audio, but keep your camera on. Thank you. Ms. Stewart, can you hear me? And I'd like to hear you.
Yes, good morning. I can hear you.
Thank you. We can hear both of you very well. Okay, Ms. Stewart, you may begin.
Thank you. May it please the court and counsel. Again, my name is Ashley Stewart and I represent the appellant, Timothy Fontenot. In order for the Child Protection Center video to qualify as a prior consistent statement, the statement must be made prior to any reason for fabrication of the allegations. In this case, the defense's theory was that HN fabricated these allegations before she even reported them to her sister, her mother, or during the CPC video. Because this was the theory of the case, the CPC video could not be considered non-hearsay, and it could not be used as a prior consistent statement. In the court below, the Court of Appeals found that the prior consistent statement should be allowed because the alleged victim here, her reason to fabricate originated at the cross-examination level when the defense attorney was questioning her. However, that's contrary to State v. Johnson, and it isn't the facts in this case. State v. Johnson says that if the reason to fabricate appears or happens before reporting, then it can't be a prior consistent statement. And in this case, that's exactly what the defense alleged, that before HN told her sister, she had reason to lie or reason to fabricate. And so again, it should have been left out as a prior consistent statement. Further,
Ms. Stewart, I'd like to ask you a question about that.
yes.
So you're arguing that the CPC interview, the forensic interview, because it occurred after she accused your client of sexual abuse, that it can't come in?
No, I'm saying that because there was a reason to fabricate before she had the video. So the defense's theory here is that HN wasn't telling the truth from the beginning, that the story wasn't accurate. The defendant denied all of the allegations. And the reasoning was because the defendant was, of course, paying for a cell phone for the victim, and he had threatened to no longer pay for the cell phone. And of course, this was the reason the defense laid out for the fabrication. And so I think you have to figure out when the reason to fabricate arose, which was before she made the statement to anyone.
Wouldn't that be cross-examination, or maybe at the earliest, perhaps the deposition?
No,
which were both after the interview.
Yes, that's the first time that the defense has to ask her about the fabrication, potential fabrication. But that's not the first time the defense is saying the fabrication arose or the reason to fabricate arose. The defense is saying the reason the fabrication arose was before any allegations were even made. And I think that's where you draw the line to determine whether a statement should be allowed in as non-hearsay. And so
I'm having a hard time understanding how could she ever make a statement I mean, you have to tell someone these interviews occur because she reports that somebody found out a revelation was made to someone and a report was made and she's interviewed. So until that moment, there's no reason for her to talk about it as far as having a statement to talk about. So wouldn't that be more kind of impossible to do, to accomplish, to ever get a statement in if it has to occur before her interview, for example?
Yeah, I think State v. Johnson lays that out very clearly. In that case, of course, there is I think a stepdaughter who was saying that, you know, her stepfather abused her adopted father. And the things that came out in that case was she made that story up supposedly or allegedly before her CPC interview or even before she reported to anyone. And in that case, which is very similar to this case, because there was a reason to not tell the truth even before the CPC video, then it can't be a prior consistent statement. So I think
Johnson's the only case you rely on. And in that case, the girl was allegedly, according to the state, ticked off with the perpetrator because he told her, hey, you need to knock off your attitude. And there was some parenting and some disciplining going on. And then she made the statement.
Yes.
So in that case, isn't that different than what we've got here?
No, because in this case, the defendant is saying before any allegations were made, he told the alleged victim here that he was no longer going to pay for a cell phone for her, no longer going to do all of these extra things. And that was the impetus to fabricate, which is very similar to the origins of fabrication in Johnson. It happened before the allegations were made to anyone.
Isn't that kind of, I mean, that sounds to me like in many, many cases talk about grooming. Isn't that just kind of part of perhaps maybe what happens in many, many sex abuse cases? Once again, my point is, could we never, ever get those statements in?
I think you can never get those statements in under a prior consistent statement. I think they would have to come in under an exception to the hearsay rule. If
Perfect.
There is no
okay. All right. Let's go. I want to move to that real quick.
Okay.
You, in your blue brief, you talked pretty much about prior consistent statement. The red brief talked about that as well as residual. And the Court of Appeals ruled just on the prior consistent statement.
Yes.
Then in your further review, you said you wanted to talk about residual, but the entire brief was your blue brief, which was just prior consistent statement. So help me understand, what is your position? What's your argument on the residual?
Okay, yes. So the residual hearsay argument here, as you know, for residual hearsay, for the exception to apply, there has to be 5 metrics met or 5 requirements met. For our purposes, we're focusing on the necessity element. And the argument here is that it wasn't necessary for the CPC video to come into evidence. Purely because obviously the alleged victim in this case was able to testify. She was able to be cross-examined. Her testimony pretty much aligned with what the video was saying. And so there didn't need to be this secondary video submitted to, in our estimation, to bolster her testimony. When you look at the residual hearsay rule, I think in State v. Vareca, if I'm saying that right, the court said that the residual hearsay rule is really used for limited, extraordinary purposes. And I think recently, or by allowing the CPC videos into evidence, I should say, in all sex abuse cases, without there having an independent hearsay exception and just allowing it to be let in by residual hearsay, is really threatening and undermining the residual hearsay purpose. And it's especially because it's for a limited purpose.
Ms. Stewart, this is Justice McDonald. What role does 91538 play here, and does it do any work independent of the residual hearsay exception?
I think it can do work outside of the residual hearsay exception. Of course, it still has the same components, some components as the residual hearsay, meaning it still has to get past the probative value test. And that's part of the necessity test under the residual hearsay. And in this case, the argument is obviously that there was no probative value with the CPC video because it wasn't the best evidence available to the state. The best evidence available to the state was obviously, in our estimation, the alleged victim's testimony. And so,
do you agree on the statute? At least it seems like it's worded that admissibility would be somewhat broader than what would be allowed under the residual hearsay exception. And the reason I ask that is the statute uses the language, it would be admissible if it, quote, substantially comports with the residual hearsay exception. And it seems like, to me at least, that means it doesn't have to necessarily meet all of the 5 factors that we've identified, that there could be something a little bit broader. Could you address that?
Well, I do take umbrage with the substantial compliance component of it. I think, at least here, talking about the residual hearsay, you have to comply, the judge, excuse me, has to go through all the specific requirements and make sure that each element is met or each requirement is met before allowing something under residual hearsay. So you have to go through the trustworthiness, you have to go through the materiality. In this case, really the necessity was a major component that needed to be addressed. Obviously, you have to go through the interest of justice and the notice. And I think when you go through all of those steps and have to comport with each specific requirement, then this test would, then this case, at least in this case, a necessity requirement would fail. And I think it's because, again, that the best evidence here was the alleged victim. She was 13 at the time. She was very clearly able to testify, unlike in other cases where the necessity bar was met. Usually those victims, alleged victims, could not testify. Maybe they were confused. Maybe they were really young. And so, or during cross-examination, they were thrown off. None of those things happened here. And the victim, alleged victim here, was able to testify before the video came into play. So the judge was able to read her demeanor and see that she was able to clearly answer the questions and see that her answers were not very different from the video. So the video ended up being just something to bolster, and there were things that were added.
But Ms. Stewart, this is Ed Mansfield. Doesn't what you're just saying, doesn't that kind of enhance the trustworthiness of the video? The fact that it's basically consistent, but provides more detail, which one would expect given that it's closer to the events in question.
Yeah, I think here, we're not necessarily challenging the trustworthiness of the video, but we are challenging that it was necessary. And I think that's really what you have to look at. Was it more than she offered in her testimony? Was it different? Did it add something new? And it didn't. And so the only reason that it was allowed was really to bolster the testimony she had already given, especially since it came after she gave her testimony. And so I think, again, the main crux here is that you really have to look at is, was this necessary? And when you go through all of the factors and facts in this case, you'll determine, I believe, that it wasn't a necessary part of the trial.
Ms. Stewart, this is Justice Oxley. It seemed like the district court kind of confused residual with the prior consistent statement when he was addressing necessity, and seemed to think that it was necessary because of the inconsistency from the deposition. Can you kind of address that, please?
Yes, I think that was a little bit of confusion. As we know, the prior consistent or the residual hearsay is obviously different from prior consistent because the residual hearsay is saying that it is being offered for the truth of the matter asserted. It is hearsay. And so the judge really needed to separate the residual hearsay from the non-hearsay components and go through each specific, back to Justice McDonald's question, excuse me, each specific element or requirement of the residual hearsay. And I think if he had done that and separated it out, he would have seen that necessity is not based on the deposition. It's really based on if it's needed at trial or if it's the best evidence. And again, I know I sound like a bit of a broken record here, but it is not the best evidence because the
Counsel Tom Waterman here. Could the additional detail in the video help support a showing of necessity?
No, I don't think so. I think the additional details in the video were some things that weren't substantiated, some things that probably shouldn't have even come into evidence. So I think some things that were talked about were maybe things that were on his cell phone that never came into evidence or never came into play as far as the elements of the crime that he was charged with. And so I think the video didn't add anything new to the proceeding outside of what the alleged victim had testified to. And
well,
so
then, counsel, isn't this harmless error if it didn't really add anything?
Yeah, I think the harmless error part that really needs to be addressed here is that it goes really back to bolstering. So, you know, she spoke very clearly on the stand, as I said, and she was fundamentally able to relay the same story. And so the fact that she then does it again via video just goes to bolster and add credibility that, you know, shouldn't have been added and should have just only been assessed with her testimony at trial on the stand. And if I remember correctly, this jury asked to watch the video again. We don't know, you know, what that went to, but I would assume if they're watching the video again, it's just a level of bolstering, and it put more importance on the video than should have been. And, you know, in this case, there was no physical evidence of any sexual abuse. Essentially, this case was just about two different versions of what happened, the alleged victim's version, and of course the defendant's version, which was a denial. And so really what the jury should have been allowed to do is just view the credibility of both witnesses on the stand without the state having the extra benefit of them being able to hear the same testimony over again via video. And so it ends up not being harmless because there was a weight put on something that should not have been admitted at trial.
You're saying right now that it was the same testimony, but didn't you argue that there were significant differences? It seems like you're trying to walk both sides of that. You talked about that your client did not touch the child's breasts, but in the video she stated she did, or he did. You also argue that it's different because your client, she alleged that he touched his penis when he touched her, but at trial that wasn't made. So there's times you try to say that it's substantially different from each other, and then you say it's not. So which one is it?
No, I don't think that the video and the trial testimony are substantially different. I agree with you that my client did deny any of those interactions. That is true. But I don't think that the video and the trial testimony are very different to where it needed to come in. The video.
You may wrap up.
So with that being said, we're asking that you reverse Mr. Fontenot's conviction and remand. Thank you so much.
Thank you. Ms. Soich?
Good morning, Your Honors. Counsel, my name is Soich, and we're here today to ask you to affirm the defendant's 2 convictions for indecent contact with the child, whether it be on the residual exception to the hearsay rule ground or the prior consistent statement rule 801 D1B ground. Your Honor, starting perhaps with the residual exception, the state is acutely aware, and the court made it very clear in Vaverka, that this is a rarely used exception, and it does have to meet all 5 criteria of the residual exception. All 5 criteria: trustworthiness, materiality, necessity, notice, and I'm leaving out the 5th one, but the interest of justice, serving the interest of justice. So before a court can admit evidence under the residual exception, they have to make all of those findings. And here, as we've already discussed a bit today, the crux of this issue was necessity. Trustworthiness, I think, under Rojas was high, so we don't have any problem with trustworthiness, but was this necessary? And I would first ask the court to kind of look at the actual language of the rule rather than our shorthand 5 criteria, because in the cases, we definitely call it necessity. But when we actually look at the language of the rule, it says, is the evidence more probative on the point than any other evidence which can reasonably be procured? So I don't think it's so much necessity as it is probative value, the most probative. And when we look at evidence,
Counsel, do you have a case where a witness testifies at trial and testifies without significant gaps of memory at trial, where a prior tape recording on the same subject matter comes in under the residual hearsay exception?
I do, Your Honor. I think the Court of Appeals has found this a couple of times. Most recently, the Scahill case, which came out, I think, on November 4th, 2 weeks ago, where the child testified, gave most of the details, and then gave slightly better or more details in the CPC interview. The Court of Appeals found, citing a couple of other Court of Appeals cases, where the same thing had happened. We had the child testify at trial.
Yeah, that strikes me as quite wrong. If you have in-court testimony that it is not pockmarked with, I don't remember, kind of poor, and here I would just say this, and please, if I mischaracterize it, correct me. But the witness was pretty detailed, gave substantial testimony. The residual exception is supposed to be rarely used. It's supposed to, oh man, the residual exception is specifically designed for kind of a rare exception where there isn't another exception to the hearsay rule that applies, but it's just compelling, and we kind of think, oh man, we just got to let this in. I don't see that here at all, frankly. It seems to me you had some pretty good testimony at trial, and the residual exception strikes me as far afield.
Your Honor, I would say that it's a matter of degree in terms of what is necessary. And certainly, as you suggest, when we have a victim who does not testify at trial or who recants, like in Rojas or Cohn, I think the victim said, I just really don't remember anything about the facts. Clearly, those come in and those are the easy cases. But I think there is this sort of sliding scale, and what we have in many of these, and we agree wholeheartedly that child sex abuse cases are not a categorical exception. The state is not arguing that anytime we have a child sex abuse case that we get to use the residual exception. That's not the argument, Your Honor. But what we are saying is here, I would push back slightly on your characterization of this victim being pretty detailed. It's about 20 pages in her direct. She's, how many times did he touch you? Over the clothes, more times than I can count. How many times under the clothes? More times than I can count. Doesn't really remember a lot, remembers a few specific things. And then, Your Honor, when you get to cross-examination, which is about 30 pages, it's effective, and he comes right at this victim. Did I depose you 10 months ago? Is it important to tell the truth? Do you agree it's important to tell the truth? Why are these other things coming up now? Why are you giving more details? Why can't you remember? What did you tell me at the deposition? What did you tell the
Counsel, this is Justice Oxley.
Yes,
So, and so I think that goes to my concern about this case, which is that the district court seemed to find necessity based on the inconsistency in the cross-examination, which is different than residual. And so so I have two questions, I guess. One is, what do we make of the district court's finding of necessity, and what weight do we give that, as opposed to what you seem to be making as a different necessity argument than the district court made? And then can you talk about the confusion between those two, the prior consistent statements compared to residual?
Certainly, Your Honor. I think that in terms of the district court ruling, it wasn't really that the court conflated the prior consistent statement with the necessity finding under the residual, but the court sort of added it to it, because the prosecutor made an alternative argument about Iowa Rule of Evidence 801 D1B and said it's necessary because of several factors. And the prosecutor's, I think, initial argument was it's 2.5 years later. This case, the CPC interview was 2 days after the allegation. It's much more detailed. So the prosecutor's original argument was it's necessary because it's much closer in time. It's much more detailed. It is the most probative evidence. Then I think, Your Honor, they do sort of throw in also as an additional reason for necessity that in this case, there was a very effective cross-examination, and the defense lawyer accused the victim of getting better and better, her memory getting better and better as the case went along.
But
you could remember this at the deposition. Why are you remembering it now? How is your memory getting better? So I think it
Counsel, so sorry, I just want to, on that point then, didn't the district court specifically say though that he was going to allow this only as a prior consistent statement and he was not going to allow it for the truth of the matter asserted? Doesn't that distinction reflect that the district court was allowing it based on prior consistent statement and not on residual hearsay?
Well, Your Honor, under either theory, it should have been allowed as substantive evidence.
Right, I agree.
So,
the district court didn't quite, might have gotten that part of it wrong, but my point is he seemed to think that the necessity was based on consistent statements and not on the idea that there had been a lot of time in between or that there was more detail.
I would urge you to find, Your Honor, that it all kind of informed his decision. But I think that really the reason that the court gave the jury instruction and jury instruction number 12 about only using it to determine credibility and not for any other purpose was as a kind of concession to the defendant. And I think in the same vein, when the court said we're going to put in the deposition testimony, and the deposition testimony, as the court will find out or has already found out, in that deposition, this victim really does not remember a lot. She's very uncertain. And so the state did not object to the deposition testimony going in. The court said, let's just put it all in. And so then the jury had the trial testimony, which was brief and sort of bare bones, I think. The cross-examination testimony, which was very effective. The CPC interview, which had all sorts of detail, not even so much about the crimes themselves, but just fleshing out all of the surrounding circumstances. And again, very close in time, 2 days later.
Soich, this is Justice McDonald. Can I follow up with a question on the limiting instruction? At least as it's applied in the facts of this case, doesn't that preclude a finding of necessity under the elements for the residual exception? So you stated the third element, according to the rule, is that the evidence has to be more probative on the point. But the way the district court admitted the evidence here, he specifically excluded the jury from relying on the CPC interview for substantive value, right? It was only credibility. It seems like, at least here, that inconsistency means it wasn't necessary because it's not more probative on the point as instructed.
I would say that it was still necessary because it was the most probative evidence, but that the court.
But probative of what?
To use it. Probative on the actual facts of the case, because
but he said that the CPC interview cannot be used as substantive evidence regarding the facts of the case. The only thing it was probative of was her credibility under the instruction.
That's right, Your Honor. And I think the court was wrong in instructing it that way, but I do think that that inured to the defendant's benefit. I think that the court should have had it come in as substantive evidence. Again, that was a mistake, but the defendant can't really complain when it was limited more than it needed to be. So I think it should have been.
This is Ed Mansfield. Getting back to the 801, the prior consistent statement exception in the hearsay rule. You know, I've always been troubled by that word fabrication or fabricate. You know, is it sufficient if the purpose of the statement is simply to show that the witness is not coming up with a story for the first time, that the story what was there, you know, that was a version of events that the witness had earlier, because fabrication is just such a strong thing to say. Usually we say the witness is not reliable. They might have a motive not to be reliable. They're not out and out fabricating. Am I reading the word right, or what do you think?
Well, Your Honor, I think there are a couple different words in that rule that we need to look at. There is the improper motive to fabricate. There's recent allegation of fabrication, and there's the improper motive. So I think that they can be two different things. And in the Johnson case, we go back to the improper motive, and Johnson, of course, changed the timeline or made the temporal requirement important, like United States versus Tome, where Johnson said if it's an improper motive case, we look at when did the improper motive arise and when did the prior statement, when was the prior statement made, and we look at the timing of those two. So in Johnson, we have someone who's trying to escape the harsh rule of her parents, and they're going to send her away, and she wants to be with her boyfriend. So the defense theory was she made this up from the start. So when you have a CPC interview that was made after she made that up, that really doesn't tell us anything about her credibility with that particular statement. And I think, Your Honor, the key in this case is that this is a recent fabrication allegation. And
Counsel, can I ask you about that point? So the same day we decided Johnson, we decided a case called Capper. Are you familiar with that case?
Yes, Your Honor.
Why does Capper not? That seems to govern closer than Johnson in this case.
I think it does, Your Honor. I think Capper is more applicable because Capper is just about prior consistent statements after rehabilitation. So I think Capper does apply. But in this case, what we have is a victim who is specifically asked, why are you making this up at trial, essentially? Oh, your memory is getting better and better. When I took your deposition, you didn't remember anything. Now you're remembering new things. You're telling me about different incidents. So the state should have been entitled to, and in this case did, give the jury that original statement where she had all sorts of detail and was able to remember things, again, because it was close in time, but it directly refuted you're making up everything at trial in the time between the deposition and the trial. So we really have a direct recent fabrication claim in this case.
Well, does that mean that in Johnson, supposing, I'm going to change the facts in Johnson a little bit, supposing the business about trying to escape the authoritarian regime of the family just arose at time of trial and hadn't been explored earlier at all, would that have changed the result in Johnson?
Well, Your Honor, if the facts were, as you say, that at the time of trial, he says, why are you just coming up with this now? I think that would have changed the results in Johnson. I think that I take that back. It gets a little confusing. I think that we have to look at when the allegation is made at the trial.
Yeah, and that's right. That's what I'm trying to probe. And I'm suggesting that if the allegation of fabrication arises for the first time at trial, does that change the environment? I'm not sure it does, but I'm asking the question because I'm not sure.
Well, and again, I think we're conflating the motivation to lie and the recent fabrication claim. The motive to lie is a different phrase in the rule. So I think we have to kind of really break down exactly which we're dealing with. We also have rehabilitation generally of a witness, which I think also applies in this case, Your Honor, because anytime a witness is attacked, we are able to rehabilitate the witness. So just on a more general level, we had rehabilitation of the witness because, again, he attacked her pretty substantially in cross.
You may wrap up, Ms. Soich.
Thank you, Your Honor. I have no idea what my time is. We would respectfully request that you affirm either on the residual ground or on the prior consistent statement ground, but in either case, affirm the defendant's convictions. Thank you.
Thank you. And I did not announce that one of the squares on our video here is the actual courtroom clock, so that will be helpful. Thank you. Ms. Stewart, would you like to respond?
Yes, thank you. I'm going to start briefly with the residual hearsay. I do want to say that in this case, there was the part of the residual hearsay, excuse me, let me start with prior consistent statement. The part of the prior consistent statement that talks about fabrication, in this case, there was motive to fabricate. The motive, again, the defense alleged was that the cell phone was going to be cut off, and all of those things happened prior to any statements given about sexual abuse. And so in this case, that's why it lines a little bit more perfectly with Johnson here, because it couldn't be a prior consistent statement because the fabrication arose before the statement. Now on to residual hearsay. You know, I think there was questions asked about during cross-examination if that's when it arises, or if that's when it becomes necessity. Here, this is a run-of-the-mill cross-examination, a cross-examination that's bringing out the fabrication and the motive to fabricate. And so just because in cross-examination, it's a heavy cross-examination, that doesn't suddenly make the CPC video necessary. The CPC video is only necessary if it's the most probative evidence. And again, here, it wasn't the most probative evidence. Obviously, our theory is that the most probative evidence was the testimony of the alleged victim here, which aligned pretty well with the video and was pretty clearly given. And the final thing I really want to say about residual hearsay is back to the part where it's supposed to be used for limited and extraordinary circumstances. We can't allow residual hearsay to be a blanket exception for all CPC videos and child abuse cases. The residual hearsay provides protections to the defendant as well. And one of those protections is that it has to be necessary. And in this case, it just wasn't. It became evidence that was used to bolster the testimony of the witness. And so it became harmful to the defendant. And so for those reasons, we're asking that you reverse his conviction and remand to trial.
Ms. Stewart, on the prior consistent statement, can you address the Capper case that was decided the same day as Johnson? Why is this not Capper as opposed to Johnson?
I think what Sheryl said was correct. There, you know, to some extent about there being different levels as far as fabrication. I think the reason that this aligns with Johnson more so than the other is because fabrication didn't arise at trial. The allegation here is that fabrication arose before the alleged victim here even reported to her sister that there was reason and a motive not to tell the truth. And if that's the case, then it aligns more with Johnson and that it can't be a prior consistent statement.
I wanted to ask you a question. You mentioned a moment ago when you were talking about residual hearsay that the video is not more probative. The video was 2 days after the allegation and the trial was 2.5 years later. Mm-hmm. Just generally, help me understand, how do you think that kind of evidence is more probative?
I think the facts of this case are obviously that the testimony, the alleged victim's testimony came first before the video. The judge was able to assess her demeanor, her credibility, and also able to compare it to the video. And again, in this case, her testimony didn't really deviate from the video. It was clearly given. Her testimony was clearly given. It was very detailed. It went over a lot of the same facts. And so there's no need for the video if you have the alleged victim testifying to what's on the video.
You know, that may be true, but I kind of wonder if you don't have a harmless error problem. It seems to me, and correct me if I'm wrong, but yeah, there's some additional facts on the video that you've mentioned and so forth. They're certainly consistent for the most part. For the most part, I mean, you know, so okay, 80% consistent, and the testimony of the witness was really pretty strong and straightforward. So help me on harmless error.
I think the harmless error really, again, comes down to the video. Remember, the jury asked to see the video again, to have it replayed for them. And then remember, this was also a case where there was no DNA, no medical things there that after medical examination that prove that there was sex abuse. So again, this really came down to one person's version against another person's. But on the state side, they had the extra benefit of the video bolstering and increasing her credibility. And so that's not harmless. That's obviously a problem. And the evidence shouldn't have been allowed in for those purposes.
In this case, the allegation, I believe, from the video as well as in testimony was never that there was intercourse. And so the DNA doesn't surprise me. There's not DNA. And you said the medical exam, there's rarely any evidence for a medical exam. So help me understand, once again, that harmless. Could you elaborate on that a little bit more? You said that the video that she testified that there was substantially the same. So can you tune in on that a little bit more? How is that not harmless?
I think really allowing the jury to hear the same things twice to bolster, to add credibility, obviously, to her testimony is something that clearly goes towards that harmless error. Or makes it not harmless error, excuse me. It shows that maybe, the jury used that when they looked at it a second time to really bolster and assess her credibility and link that to her story being more believable than not. And if that's the case, then it wasn't harmless.
Counsel, we often find a harmless error when evidence comes in that shouldn't have come in, but it's merely cumulative. So if the video is just allowing the jury to hear the same thing twice, isn't it cumulative and therefore harmless?
I think it's not just hearing the same things twice. It's really showing that that she's more believable because this happened, because the video and because of her trial testimony. I think that's the problem here. I think, again, when it's one person's word versus the other, any slight evidence that's going to tip the balance unfairly towards the other side makes it not harmless. And that's what happened in this case.
Thank you. You may wrap up.
Thank you, Your Honors. Again, all we're asking is that you reverse his conviction and you remand for a new trial. Thank you. Justice Christensen, you're muted, so we can't hear you.
Oops. Thank you. I told you guys to turn it on and off, and I forgot. Thank you. The case Fontenot, State versus Fontenot, is hereby submitted. We will take a brief pause while the court prepares for the next oral argument, Benskin versus West Bank. Thank you.